Swayam Prabha. Digital India. Educated India.
Hello everyone. The topic which we are going to talk about today is on intellectual property rights and innovation. The overall organization of this topic is as such. First, we will discuss about the meaning of intellectual property rights. We will also look into the basics of different types of intellectual property rights, namely patents, industrial designs, trademarks, geographical indications, and copyrights. The next topic we will pick up is regarding the internationalization of intellectual property rights and what is the history of patent rights in India. Very specific aspects about the patent policy of India. Towards the end, in the context of the innovation system, we will understand what role is being played by intellectual property rights, what is the economic rationale behind providing these rights, why do we find so many economists working in this particular area, and the empirical research that has been conducted to understand the relationship between IPRs and innovation system and its different components, what does the studies find or reveal for the further policy interventions. So to begin with, we look at the term intellectual property. It essentially refers to the creations of the mind. Human mind, with its creative activity, can come up with inventions, they can produce literary and artistic work, they might come up with new symbols, images, and we may find that this kind of an intellectual property or the mind creations has the possibility to be used in the commercial activities. Since the different types of intellectual properties can be created, what we find is that the different types of rights are also being created so that the protection can be given to them. As a result, what we have is an intellectual property rights, which is a bundle of the legal instruments. Each of these, they will vary. They vary in what? They vary in scope, they vary in duration, and the different purpose and the different effect it may have on the economy. So what we find, as I said earlier, intellectual property, it essentially is about the creations of the mind. One very basic question in that case arises is that why these rights have been provided. So in our economic rational aspect, we will deal with the economic theory, but to give you a very basic intuition, what we find is that these rights essentially gives the owners of this intellectual property a kind of a right to stop others from imitating the product. Now think from a point of view of a creator who has with lot of hard work, effort, and has spent lot of time in coming up with a newer product or maybe a drawing or maybe a painting. Now once that particular output is there in the market, or whether he or she has shared it with somebody, what we find is that a lot of imitations have suddenly appeared in the market. Now from the point of view of that particular innovator, clearly or the creator, it is going to be very disheartening. As a result, what we find that these intellectual property rights will protect them to ensure that nobody else will be very easily copying their creation and will be disseminating their creation in the market. As a result, what will happen? The creator will be able to disseminate their own creative outcomes in the market much more freely. So that is one very common element which we find in these intellectual property rights, whereby it gives the rights to the creator to protect the outcome which has come out of their creative mind. But does that mean then why are they not the same? Why we don't have a single intellectual property right? Like I said earlier, the creations of the mind might lead to different kind of outcomes. If the outcomes are different, they may require a different set of protection. To give you an example, suppose there is a new drug which has been which has come in the market, a new book which has been written by an author. So if that happens, then clearly book vis-a-vis a medicine is a very different outcome. we have provided different set of legal instruments to protect them. As a result, we have this intellectual property right as a bundle of the legal instruments. So do they vary? Yes, they vary. They vary in terms of what they cover, what kind of a duration they provide the coverage for, and the purpose that they might be introduced with. Clearly, they also have a different effect on the companies or the creators who are now using them to protect their own creations. So in that sense, this very broad and a very basic way to look at the intellectual property rights, we find that they can be distinguished into two types. One is industrial property, another is the one which is related to copyright and related rights. Within the industrial property, we will find patents, industrial designs, trademarks, and geographical indication. The IPRs which are listed on this particular slide are essentially statutory. That means they have been provided through the act of law, or a law or a bill exists, or an act exists in the country to protect these kind of rights. One very important characteristics of this intellectual property right is with respect to their nature. What we find is that they are territorial in nature. What do you mean by this? Territorial nature essentially implies that if you have received any kind of a protection, that will be applicable to a specific geography in which that has been taken. So if you have been given a patent or a granted patent by under the Indian Patent Act, so the rights will be limited to the geography of the country, that is India in this particular case. Just because you have been granted in a patent by the Indian Patent Office does not mean that now you can go and also will be able to use it or stop others from copying in the other countries, say for example Pakistan, Bangladesh or Nepal, etc. So if you want protection for your creation in other countries, essentially it would mean that you have to go and take the protection in the other countries, whether you take patent, industrial design, trademark or geographical indication. So first let us begin with what do you mean by a patent. Now this discussion I begin with thinking of a particular, let us say, an invention. All of you must have seen water bottles, right, which we use for our daily use, and nowadays we have also seen specific bottles that have come which will show you the temperature of the water which it contains. Now suppose you come up with a new product, same a water bottle, but it is something which you have put some special sensors to it, and you have also maybe done some designing in it such that the sensor assess the the temperature of the room and accordingly either cool or warms the temperature inside the bottle. So this is something you have. So when now you go forward and you want to see that you want to now commercialize this particular product, let us say in the market, you realize that people may come, they will swarm the market, and there's intense competition in the water bottle section, and you want to protect it. So which kind of a protection you will be going forward with, that is what will become clear as we will discuss each one of the IPRs separately. So we will discuss patent, copyright, trademarks, geographical indications, industrial design separately, highlighting the scope, highlighting what are the rights which have been given and other special characteristics. So keep that bottle in the mind and try and now look at these various IPRs. So if I say talk about patent, the slide says it's an exclusive right granted for an invention, which can be a product or a process. So when we are talking about an invention, essentially the protection through a patent can be given for a product or a process that will provide a new way of doing something. It will also need to that it should provide a technical solution to the problem. So the bottle which we have in the mind is not only taking the temperature of the water which is inside the bottle, but at the same time is also taking at the temperature inside the room in which it has been kept. So in order to be patentable, the invention needs to meet what is very popularly known as a patentability criteria. The patentability criteria engages three kind of steps. The first is it should be new or a novel, it should involve an inventive step, and it should have industrial application. So let us discuss about the patentability criteria in detail. The first one is with respect to novelty. It implies that this new invention is not anticipated in the prior publication, prior use, or prior public knowledge, effectively implying that there should not be any information available with respect to that invention in the public domain. As a researcher, when we start our research, what we do is a literature search. So here what an examiner will do is a prior art search to ensure that the novelty of that particular invention which is now under consideration for the grant of patent is determined. The next step is with respect to non-obviousness. Here the idea is that it's any other product which is being now created, it should not be a mere combination of few, and there should be something which shows that it is not a very obvious thing to be done by the person who is now skilled in that particular field. The last one is with respect to industrial capability. Essentially here we are looking in terms of the commercialization aspect, whether it can be scaled up, can be produced, and can be industrially applied. So if you now can go back to the bottle which we have thought about earlier and can now use this patentability criteria to assess whether it will meet it. So here thereby you have to go forward and then look at whether this kind of a bottle has been talked about in the literature earlier or not, whether something is talked about, any other product has talked about putting together, a kind of a sensor which will assess the temperature of a room in a product itself. So again, you have to do a prior art search to understand whether there is a novelty in what you are now claiming to be a patent. Clearly, you also have to see that it should not be merely a putting together of the few things. For example, you have put a small watch in a pen and you want to see that okay, while writing you should be able to understand pen. So simply you are putting together two things, whether it can be granted patent or not on the criteria of non-obviousness will be doubtful. So then again, with respect to the industrial capability, which is a relatively easier concept, the idea here is that industrial application of the product should be there. Right? What kind of protection is being given, for the inventions which has been now granted a patent? There you see that the patent protection essentially means that the product or the process for which the patent has been granted cannot be commercially made, used, distributed or sold without the patent owner's consent. So if you have not been lucky to get the patent over that bottle and you find that another company or a small enterprise or somebody else is now copying it and selling it in the market, then you can definitely stop them from doing so, because the right gives you that you should be able to make it, use it, distribute or sell it. The patent protection which is being provided is for the 20 years time period only. It is not a perpetual kind of a protection that is being given. In economics, we will talk about why this term has been kept to be 20 years. Essentially, the idea is that patent will lead to a certain amount of monopoly in the market, and that monopoly cannot be perpetual. There is the need to put a time constraint on that. Next is, as we have talked about, it's a statutory right to the inventor or applicant which is being given by the government for his invention, which is either a new process or a product. There are certain key features, like I said earlier, that the patents have been granted for a limited time period. It also needs that the patentee or the person who has now applied for the patent application, in the application process should elaborate on the invention itself. That would effectively mean that once the invention is being, let us say, granted the patent, the entire patent related document will be available for the public to look into it, to learn from it and to take it forward, not to copy it. Let us make a very clear distinction between copying and using it for the further research. Project also requires that you need to take information from some earlier patent. You can always do that with proper referencing, etc. The patent law, it stops you from commercializing the product and selling it. This disclosure, in fact, a major trade-off which we realize exists in terms of the monopoly right which is now being granted by the government to the patentee, in lieu of the information related to the inventions that come through. Territorial right we have already discussed, and another important characteristics or the feature you can say is that they are negative right. Negative right here implies that it will be able to stop others from doing something. So that is why it's a negative right. However, please note that once a patent expires, the patent protection ends and an invention enters into what is a public domain. So the question again is that what kind of rights are being held by the patent holder? A patent owner has the right to decide who may or may not use the patented invention. Now, thinking from the same bottle example, suppose there are certain companies who become very interested in this particular product. There is a possibility that the person who has been given the patent, he or she may not have the capabilities to mass produce the product, because that will require a very different set of asset and a knowledge. So mass production vis-a-vis the major innovation which happens. As a result, they may think of still using it by giving a license to the other companies or the major firms, and those companies will be able to produce it. Note that when the license is being granted, that does not mean that the invention will be losing the control over the patent. The company which has been licensing the particular patent, they would be obligated under the contractual agreement to give certain amount of a royalty or a lump sum payment as per the agreement for the use of the patent as such. Lastly, the patent holder may also decide to sell their rights in case if they realize that he or she has not been able to use the invention as such, then they might sell the rights of the invention to some other company or an enterprise or maybe another individual. So once an application for a patent is being made, before checking the patent for a patentability criteria, what we find is that not everything is patentable. There are certain exclusions, and what are those? So as per the Patent Act, so these are the select few, there are more also, you can go back to the Act and have a look. But here for instance, something is frivolous or which is contrary to the well-established natural law, contrary to the public order or morality, serious prejudice to human, animal or plant life or health or to the environment, any kind of a discovery of the scientific principle or the formulation of an abstract theory or discovery of any living thing or non-living substances occurring in nature, a method of agriculture or a horticulture, the mere arrangement or rearrangement of duplication of known devices, each functioning independently of one another in a known way. For instance, I gave you an example of a pen with a watch. Any process for the medicinal, surgical, curative, diagnostic, therapeutic or other treatment of animals to render them free of disease or to increase their economic value or that of their products, a mathematical or a business model or a computer program per se or algorithm. Now this list of exclusions, please note that this would be as per the Indian Patent Act. Clearly, the different countries may have something more or less than this particular list as such. So the types of patents which are granted in India includes an ordinary patent, which is essentially an application for patent filed in the patent office without any reference to any other application under the process called an ordinary application. If an ordinary application has been made and then a certain improvement or modification is being done and another applications come to that, so that will be under the patent of addition. In the Indian Patent Office, we will realize that the patent applications are not only made by the Indian residents, they are also made by non-Indian residents. So they come from the foreign nationals. The foreign national applications can come through two major channels. One channel is through which the foreign applicants simply apply. The another one is under the Patent Cooperation Treaty. This particular treaty has been signed by the member states in order to facilitate the process of the grant of the patent in different countries. Please note, it does not lead to grant of patent in many countries. It merely facilitates the process. This is in the context of the territorial nature of the patent and the other IPRs, whereby I mentioned that a particular patent will be applicable within the geography or the territory of the country. If that is the case and you feel that the particular bottle which you have come up with now will have market across various countries, that will essentially mean that now you have to go and patent your invention in other countries, which is a very time consuming process and it will also be very costly. So in order to deal with the challenges which comes with respect to patenting in the different or a multi-country by a particular company or a patentee, a PCT has been agreed upon and has been signed by various member states. India is also a member state. So there can be applications which will come through the so-called PCT route. So those are called as the convention applications. Once the patent has been granted, it will cease to exist or it will expire. So under what circumstances? So one is the most important, like we said, that the term of the patent is 20 years. So once a patent finishes 20 years, it has lived its full term. However, the question arises, if the patent has been granted, whether the applicant or now the patentee will be able to keep it just like that? The answer to that will be no. They need to renew it. They need to pay what we call as a renewal fee with the regular intervals. So if the patentee now fails to pay the renewal fee, then also it will be ceased to exist. Then the validity of the patent can also be challenged before the grant in the Indian context and as well as after the grant of the patent. Now, if suppose the validity has been challenged and it has been successful, under those circumstances also the patent will cease to exist. Coming from a very practical point of view, there are different steps which are involved in the grant of the patent. So what do we start with? We start with filing a patent application. At that stage also we are required to pay the fee. Then once the patent has been filed, it will be checked for the regular items which are contained in there, the formal requirements which are there, and it will be accepting the application with the due fee. After that, the application is kept secret for a period of 18 months from the date of filing. After that, in 19th month, the application is published in the official journal. This official journal of Indian Patent Office is available on the website and it also publishes weekly. After that, the applicant will make a request for the examination and the examination will be undertaken. What will the examiner check the particular patent for? The patentability criteria which we have discussed earlier. They will check whether the claimed invention is to be prohibited or is prohibited for the grant of patent, whether it meets the patentability criteria, and after that a report will be generated. The report might have some questions which the patent applicant would be required to answer in a limited time duration. If all the answers are being met and your application is in the order as expectation, then the patent will be granted. I would have very casually gone over all the steps. There are various minor steps to each one of those as well. So first, examination containing list of the objection is issued within the 6 months from the date of filing. Applicant gets 12 months to meet the objections. If objections are met, then patent is issued by the controller within a period of 1 month and published once again in the official journal. So this is the flowchart for filing of an application. Publication, request for examination issue of examiner actually issues your first examination report. Objections has to be replied to. If they has been replied successfully, then the patent will be granted. As I said earlier, in the Indian context, one can raise objections to the patent either before or after the grant. So once the opposition has been raised against a particular patent, you will find that it will be contested and the decision of the controller in that case will be final. Also note that there is a specific fee structure which has been provided by the Indian Patent Office. There are different rates for e-filing and physical filing. These rates vary from whether the filing has been done by a natural person or a startup or somebody else. The amount vary from 1600 to 18,000. In fact, recently Indian Patent Office has also come up with a procedure whereby the startup grant can be expedited. The entire process from the date of application to the final grant of patent in a normal case might take 3 to 4 years. So there has been concrete efforts being made by the government and the administration to reduce this particular time period by increasing the efficiency of the patent offices. What we have found that they have provided for expedited examination for the startups as well as for the educational institutions. Apart from that, so accordingly the fee would be paid by these institutions and the startups for the expedited examination. However, the fee is rather nominal. For each sheet of the specification which is covered in the patent application and the claim, there would be different charges. Fee payment will be required at the different stages. This is very important for us to know that it would be request for examination, early examination, publication, withdrawal, etc. Then the renewal fee also has to be paid at the regular intervals. It has to be paid within the 3 plus 6 months from the date of recording in the register. No fee in the first and the second year. Patent will lapse if the renewal fee is not paid within the prescribed period. Having understood patent as one type of intellectual property rights, now we will have a brief overview of the different other types of IPRs, including your industrial design, trademarks, geographical indications, and copyrights. Industrial design is essentially a right over an ornament or an aesthetic aspect of an article. The design may consist of three-dimensional features such as the shape or a surface of the article, or offer two-dimensional features such as patterns, lines, or colors. Industrial designs are applied to a wide variety of products of industry and handicrafts, which includes technical and medical instruments, watches, jewelry, luxury items, housewares, electrical appliances, vehicles, architectural structures, textile designs. Industrial design is primarily of an aesthetic nature, and it does not protect any technical feature of the article to which it is applied. However, please note that purely artistic design that cannot be applied to any utilitarian objects are also excluded. And industrial design, like we talked about in a patentability criteria, for an industrial design, it must be new or original to get the protection. Generally, new here means that no identical or very similar design is known to have existed before. The duration of protection available is 10 years. Like in case of patent, the owner of an industrial design, that is the person or entity that has registered the design, is assured an exclusive right against unauthorized copying or imitation of the design by the third parties. Moving on to the next one, that is trademarks. Any sign or a combination of sign which is capable of distinguishing the good or a service of one company undertaking from that of the another constitutes a trademark. These trademarks can include letters, numerals, figurative elements, and a combination of colors, etc. Trademark, it will help in identifying the commercial source of a good or a services. So in your day-to-day life, whenever you are looking at a different products, whether you are looking at soft drinks, whether you are looking at shoes, whether you are looking at jeans from different companies, you will find that each of the companies have their trademarks. Not only the companies which produce goods, but also the one which provides services also have the trademarks. For instance, there is a very specific mark of Airtel or that of a Vodafone. They have very specific tunes that belong to them. How that helps the consumer? It helps the consumer in identifying that particular product actually belongs to that particular undertaking, and in the process reduces what is known in economics as information asymmetry. So information asymmetry is a situation in a market whereby one of the party to the transaction does not have sufficient information. Say for example, you go to a local market in your city to a particular, maybe to buy a jacket or to buy some shoes. That particular market may not have a very good reputation of selling the original goods. But once you enter the particular market, you realize that somebody is now selling you a jacket at a very low at a particular price. Now you do not know whether the product is of a higher quality or not, but it does bear a certain mark, and the mark is similar to the one which is now being of that of a popular brand. So in this particular market, there are two parties to the transaction. One is you and another is the seller. But the seller has more information about the product in the sense that whether the product belongs to the original company or not. As a result, you will find that this particular market situation characterizes that of a market information asymmetry. It is the information between the buyer and a seller in that context is not symmetrical. The response of the buyer in that case would be to try and elicit the information from the particular seller. In that context, using that mark can be very helpful. The mark can actually signal whether the product belongs to that particular company or not. So you will take the jacket from that particular person and will examine the mark very closely. You will also look at the other tags to ensure that whether the product belongs to the certain company from which you have in your mind to purchase the good from. So in that sense, the trademark can be helpful in determining and helping the particular consumer whether the product is of a certain quality as per the expectations of the consumer. In the market, apart from trademarks, we have collective marks and certificate marks. Collective marks are essentially owned by associations like a nursing association. A member will be able to use them, will be able to show that they identify with a certain level of quality and other requirements which are set by that particular association. Certification marks are slightly different. Why? Because it requires that the company or the particular firm which has been now certified actually meets the requirement of the certifying agency. That means certain standards have been defined, has been set, and then there is a need for the company to comply with those defined standards. The certifying agency will allow the particular firm to which it is now giving that certificate to use the so-called design in their particular advertisement. You would have come across ISO 9000 as a quality standard, which is very widely used for a recognition certificate. The next one in the line is geographical indication. Here I would like to highlight that the economic rationale for providing trademark is different, and geographical indication actually varies from the economic rationale that exists for the protection of the patents, whereby we find that in case of a trademark and geographical indication, the major objective is to reduce the information asymmetry that exists in the market. However, geographical indication also varies significantly from trademark. Let's find out how. Geographical indications are essentially the signs which are used on goods that have specific geographical origin, and they possess qualities or a reputation that are due to that particular place of origin. Think from a point of view of Darjeeling tea. Darjeeling tree is grown in a particular valley of Darjeeling. It has certain soil characteristics, it has certain temperature which stays around in that particular area, it has certain humidity in the air, and as a result, the geographical factors of that particular area contribute towards determining the product quality, including the climate as well as the soil. Apart from that, what we find that those leaves from the particular tea plant, they are being plucked at a particular time in the morning in a specific way. After collecting those leaves, the human factor enters into picture in the sense that a certain manufacturing technique, which may be a technique that has been established, an age-old technique, or has been developed, the traditional production method, and as a result, when you have that particular tea, it leaves you with a sweet bitter taste in your mouth. So the qualities of the Darjeeling tea in that case is attributed due to the very specific local geographical factors as well as the intervention which is through the human factor. Human factors has determined the production process, and that production process has been established traditionally over a period of a time. As a result, the product now has its own characteristics owing to the geography, and we should be able to use some kind of a method through which that can be attributed also. As a result, what we have are the geographical indication. Most commonly, it consists of the name of the place of origin of the good. For example, I told you about Darjeeling tea. We have Nilgiri tea, we have Swiss watches, we have Roquefort for cheese, which is produced in France. We have Tuscany for olive oil, which is produced in specific area of Italy. There's champagne. And in the Indian context, we have Bengali rasagullas, we have Ratlami sev coming from Indore, from Ratlam, sorry. And then we have part of the country has now the various products documented under the geographical indication. As I said earlier, geographical indication are essentially there to protect the consumer, to tell them that this particular product belongs to a certain area. The tea which we are going to now take comes from the specific region, or the watches which are we going to now purchase, it's actually being produced in certain countries. So as a result of the reputation which has been acquired by these particular products over a period of a time, if they are not adequately protected, then the products can be misrepresented by the dishonest commercial operators. So if the major reason for geographical indication and trademark is the same, that is to deal with the problem of information asymmetry in the market, how we can distinguish them? So we have to understand the basic differences between them. From the geographical indication, it will identify that the product is produced in a certain place and has certain characteristics which are because of that place of the production. Whereas in the trademark, it is the commercial undertaking which will be important. Then a geographical indication can be used by note that all the producers who make their product in the place designated by the geographical indication and whose products share typical qualities, whereas trademark can be used by a single producer. The last intellectual property right for which I am going to give you an overview is about copyrights and related rights. Copyright is a legal term which describes the right given to the creators of the literary and artistic work. It extends to expression, not to the ideas, procedures and method of operation or the mathematical concept as such. Different kind of work can be covered by the copyright, which includes literary and artistic works like novels, poems, plays, reference works, newspapers, computer programs, databases, films, paintings, drawings, photographs, architecture, technical drawing, etc. The original creator of the work holds the exclusive right to the use and authorize others to use the work on an agreed terms. The creator of the work can actually stop the others from its reproduction in various forms, whether it is printing, a publication or sound recording, the public performances that can be made out of it, or of its recording on a cassettes or a videotapes, its broadcasting by radio, cable or satellite television, its translation into other languages or adaptation such as novel into screenplay. Note that the many creative works which are protected by copyright require mass production. For instance, you have written a novel, then that novel will remain with you if you are not able to make copies of it and being able to sell it in the market. Now, being able to publish a particular book and then be able to mass produce it will require a very different set of skills. Many a times you will find that the authors, they may not have that kind of a capability, thereby they will be able to mass produce and disseminate their books. As a result, they will go to the different publishers who would have invested in publishing house and will be able to mass produce the product and sell it. Thus, what happens is that the creator will often sell the rights of their work to the individuals or the companies who will be, and as a result will be able to make the work returns in return for the payment. The product will be now available in the market to be sold to the masses, be read, and the author will be able to get the payments in the return. These payments are often made dependent on the actual use of the work, may be related to the actual number of the copies of the book that will be sold in the market. Apart from the moral economic right which is there with the author and that gets transferred during the process of getting it mass published through an appropriate copyright agreement, there are also moral rights. The moral right of the copyright, it always belongs to the author, which actually involves the right to claim the authorship of the book and the right to oppose any kind of a change that might be introduced which will affect the creator's reputation. Apart from the copyright, there are related rights which are that of the performing artists, such as actors and musicians in their performance, producers of sound recording in their recording, broadcasting organizations in their radio and television programs. In the recent held IPL, you would have noticed that the broadcasting organizations are very particular about their rights over this. These rights are they are something which grew up around the copyrighted work. So now, coming to an end, let us look at this refrigerator. I took this initial example from a World Intellectual Property Organization website, whereby a very interesting refrigerator has been presented. In the refrigerator, what you will find that there is a world of intellectual property. So let us look at the aesthetic element of it. That means how the particular doors have been designed, how the particular knobs would have been put together, how the different buttons would have been designed, maybe that of a temperature control, etc. So that needs the protection of the industrial design. There are going to be branded products in this particular refrigerator. Like you can see, there is a bottle of Pepsi or maybe any other drinks. So that will be now protected through your trademark. Might be there are certain cheese which are lying in it. That will require a geographical indication kind of protection. Apart from that, there is a special packaging which is being used, like that of a cane and then vacuum packed, or maybe a key cane openers, and that would require the protection of the industrial design. There is going to be a mechanical element to that refrigerator. For instance, someone comes with the compressor, which when cools the refrigerator also manages the temperature of the particular room in which it is kept. And as a result, that kind of a part of the process or of the particular product, the compressor itself, can be liable for the patenting. Then lastly, there will be an operating manual with the refrigerator, which will give you all the details about it. And as you have guessed it right, that will be protected under your copyrights.